Abdiya? Okay, hang on.
Vishnu Mohan Rao. I work with the Citizen Consumer and Civic Action Group as a senior researcher. I lead the electricity work in CAG. As you know, Bendy has pointed out that CAG, Citizen Consumer Civic Action Group, is a, as the name suggests, it works on citizen, consumer, and civic issues. We have it's a 35-year-old organization. We work on a whole host of issues on waste, environmental governance, urban governance, electricity related issues. And we have a dedicated consumer desk in CAG that was started again 35 years ago, that basically looks at helping consumers address their everyday complaints. It could be a cell phone connection that is not addressed by the service provider. We do it free of charge. That's the way CAG started. Over the years, we have, as pointed out, we have diversified our area of work. We have included electricity as one of the main topics. So based on this, this particular on electricity governance, we have seen a lot of work around consumer participation, improving the quality of their participation in the sector. And over the years, we have started, setting up consumer cells in the districts, which kind of seek to, address consumer grievances in the sector. I think this is a brief of what CAG does in terms of the larger work that we try to do. Is we build a lot of capacity, we build awareness, we do action research is what we like to call it, and we kind of advocate several positions on what we feel is the right way forward for the sector. So coming to the topic at hand, see, this is kind of what we took. I took this as a kind of an exploratory research in the first sense, but as I read the work that I read some of the things, there's got to be a very tangible difference that we can probably make in this sector through this particular intersectionality of competition law and electricity sector. The idea being that as CAG went along its work, we found that several regulations that are kind of coming up, and it doesn't seem to be in line with what the Electricity Act would normally like to look at. If regulations such as, I found a classic example for me of how stifling competition is, and it kind of reduces consumer choice, is the whole aspect of the net meter. So you have a roof, Electricity Act has said you must promote distributed renewable energy. One of those means of promotion is rooftop solar. And the regulations, there are various state policies on rooftop solar. There are regulations around rooftop solar. But when it actually comes to the implementation aspect, regulations for rooftop solar, you have a feed-in tariff where you can export power to the grid, and you can get some money for the solar rooftop solar that you've put up. But to export power, the whole aspect of the exporting power part is you need to have a meter. That is a technical stuff. It allows you to account for the exported power and account for the imported power. It's called a bidirectional meter. Unfortunately, the bidirectional meter, unfortunately, the bidirectional meter is given with the utility. It's the property of the utility. Yeah, thrives on selling power, will not exactly like to have its consumers move away from its consumer base and being independent of the grid, and as a result they lose revenue. So if a utility has purview over a critical component such as a smart meter, in a bidirectional meter, then it loses that. It has all the more reason for it to retard the growth of rooftop solar. Regulators are looking at administrative efficiency. Are they really looking at promoting competition is the kind of the moot question here. Is it something that we need to look at? And also I was talking to Bhargavi and Kiran were leading this research work for CAG. The idea is that where does competition start and where does regulations end? So I'm reminded of a very nice line from Stephen Littlechild, who basically says that regulation holds the fort until competition sets in. So regulation is holding the fort, making it into a kind of a creating a conditions for perfect competition to exist. But have they overstepped their bound? Is there where is it that competition has to intervene and play that role? So again, the jurisdictional issue is what we kind of thought about, where competition authorities I think do not have the jurisdictional influence on Electricity Act. Regulators are dominant. Then who checks the regulations? Is it if it is comparative or not? That's one way to see that. And who oversees if regulatory bodies are passing optimal regulations to promote consumer choice? See, again, the whole point of competition is improving consumer choice. Otherwise, you have a social deadweight loss, as you call in microeconomics. So the whole orientation of moving towards perfect competition with the regulators as proxy competitors, is it really something that we need to really work on? But as I know, in my line of kind of work, I'm trying to figure out if regulators such as in other countries, I find that there is a slightly different position where regulators have to pass the competition litmus test, whether the regulations actually competitive or not. So that's something that we need to figure out. And the structure of the organization structure or the hierarchical structure is usually that probably regulators form regulations and then competition authorities have an oversight over whether the regulations are competitive or not. So is it something that is it prevalent in the Indian context? So these are things that we are thinking about. One section that struck me to start off this whole thing is the Section 60 of the Electricity Act, which looks at the market dominance and the abuse of monopoly status and those things, and that have regulators scrutinize that position, and how can we equip them to scrutinize that position better? Can competition authorities play a role there? Can there be a larger collaborative way in which competition authorities and regulators form a forum? It could be the forum of regulators. Can forum of regulators have competition authorities play a role in the forum of regulators, equip them? So these are things that these are all questions that kind of come up in the overall process of work that I was looking at. So Kiran, Manohar, and Bhargavi are young dynamic researchers that have kind of come forward, agreed to take this work, and found it to be exciting. So I hope from the panel, the esteemed panel members who are in the thing, they will be in a position to enlighten us, while kind of give some more. And again, this is as Kiran has mentioned, this is kind of a research work. We have a webinar series. It's not one or two. We have 3 to 4 webinars that we have planned. End of the webinar, we've got a series of policy briefs, and end of this kind of thing, we're looking at a report which will possibly enlighten regulators as well as competition authorities, as well as the Ministry of Power and other other bodies that are in the electricity sector to give them a different thought. So again, the implications for Consumer Protection Act, all these are kind of need to be integrated in this whole aspect of this whole jurisdictional turf war, as I call it now. It comes to my mind that this should not be a turf war, or more a collaborative effort on how we strengthen the sector, as well as give consumer choice, better consumer choice. Yeah, thanks. I think I end my thing with this. Bhargavi, are you going next, or Kiran? Please take the floor. Yeah.
you, Vishnu. Formally, very good morning to all of you. It is absolutely delightful to see so many participants.
Sorry to interrupt, Bhargavi, but the audio was a bit low. Could you?
Okay.
Perfect. Now it's perfect. Please. Thank you.
Is it better now?
It's much better now. It's much better.
Great. Yes. So I'll start over. So very good morning. Great to see all of you joining us on a Saturday morning like this, especially over a long weekend. And thank you, Vishnu. That was a great introduction to the topic. I will just quickly introduce our panel of speakers for the webinar. We are extremely excited to have all of them on board. We have been collaborating on this topic and discussing it extensively with Vishnu and our speakers. So to quickly introduce the speakers, our first speaker is Mr. Mukund P. Unny, and he is currently an advocate practicing before the Supreme Court of India. He practices extensively in the areas of electricity laws and energy laws. And he has appeared in matters of great constitutional importance, like the 370 challenge, the Kashmir challenge, the CAA challenge case, the Sabrimala case. He is also a regular columnist for publications like the Hindu, the Indian Express, and Live Law. And he's done extensive work in the sector that we are keen on exploring through this research project. So thank you, Mukund, for taking time out from your extremely busy schedule. And we are very excited to hear you speak today. Our second speaker is Mr. Prashanth Sabeshan. He is a partner at a law firm called AZB and Partners in their Bangalore office. He heads the infrastructure team there. So he has also worked overseas in countries like Australia, in Singapore, in Indonesia, and he has extensive work experience for over 23 years in the areas of construction operations, infrastructure, project financing, energy and clean energy projects. He has also recently authored a book titled Investing in India's Infrastructure and Energy Sectors, Laws and Practice. So this book was published by Thomson Reuters in 2021, urging all of you to kindly purchase and read the book. It's excellent. I have personally gone through it. I'm very excited to have Prashanth sir on board. Thank you, sir.
Thank you.
And our final speaker, Mr. Ramani, he is, to say, an industry veteran. He comes with extensive experience of over 39 years in the areas of energy, infrastructure, and IT. In fact, he is currently the Chief Executive Officer in companies called Energy Space and Windia Green Power Private Limited. He is an advisor to several corporate giants like L&T, for example, and he comes with extensive industry experience, and his insight is going to be extremely interesting and unique because we are a panel of Kiran and I are both practicing lawyers. Mr. Mukund and Prashanth are again lawyers. So Ramani sir is going to be that person who is going to give us an insider perspective to this entire topic. And we are very excited to hear him speak as well. Now, to take up too much of time, I invite Mukund to kindly start with his presentation. Thank you.
Good morning, everyone. Thank you, Bhargavi, for that kind introduction. Thank you for having me, CAG. I'll just share the screen. Is it now visible?
Yeah.
Yes.
All right, this should be okay, right, in terms of viewing?
Yes.
Please go ahead.
Right, yeah, so I will be speaking briefly about the intersection of electricity law and the Competition Act. When I endeavor to do that, I would try to give a bird's eye view into how both the laws are playing out, and I'll only briefly talk about it because we'll have Prashanth sir also to give a much more expert view on the subject, and we'll have the industry view of Ramani sir also. So to set the tone, I'll have a introduction about the topic, and I'll also talk about few cases where the issues with respect to the Intersection of Electricity and Competition Act have taken place, mostly in CCI. So we have the Electricity Act of 2003, which was enacted after a really long time of discussion and all that. So when the Electricity Act was enacted, we already had the Electricity Supply Act of 1948, which was holding the ground. And sometime in 90s, we also had the Electricity Regulatory Commission Act, where that made it mandatory for the states to have their own separate electricity regulatory commission, so that there will be a structural regulation. But ultimately it was felt that we need to have a uniform law, and we can't have multiple enactments on the sector. And ultimately in 2003 we had a Uniform Electricity Act for the whole of the country, because electricity in concurrent list. Substantial power of electricity with respect to electricity goes to the states, and the role of actually playing the role of regulator would also be on the state electricity regulatory commission. There as we all know, we'll have the central electricity regulatory commission also, if the matter is pertaining to 2 or 3 more states. And then we have the Joint Electricity Regulatory Commission for the Union Territories. That's how the basic framework is. And I'll just briefly talk about the Statement of Objects of Electricity Act, which is also very important for the present purpose, because it very specifically deals with the aspect of competition. The aspect of competition has been highlighted in the Statement of Object or preamble of the statute itself. So here we have the Parliament saying that the law is enacted for taking measures conducive to the development of electricity industry as a whole, and most importantly for promoting competition in the sector. There was stagnancy in the sector. Most of the companies which were state electricity boards were facing a lot of losses at that point in time, and this act was enacted. It's no different even now, but it was expected that the act will bring about a lot of reform and bring about a lot of competition. It's another matter whether the object has been achieved. Another object of the Electricity Act is also to ensure that the interest of consumers are protected. So that is, according to me, the most important aspect, because consumers are the most important stakeholders of the sector, and whether the interest of the some consumers are subserved is something which will have to be taken care of by the lawmakers. So this is what the object of the Electricity Act says. Okay, so now I'll just briefly talk about the law, the Electricity Act, and also regarding the sector. It's a heavily licensed sector. For even moving a pen, you need to have a license. We have a section 14 of the Electricity Act, which says that for transmitting, distributing, and for undertaking trading, we need to have license. So as you all know, there are 3 aspects for the in the market. One is distribution, ultimately distributing the electricity to the end consumer. Then transmission from the generating house, from the generating terminal to the to the distributing licensee, and then we'll have the actual aspect of generation of electricity itself. So except for generation of electricity, for transmission and distribution, we need license. And for most of the other things also concerning electricity, a license is required. So section 17 says that licensees can't do certain things. So such aspects have also been mentioned in detail in section 17. And the distribution licensee, who is the end distributor of electricity to you. For example, if you're taking the case of Tamil Nadu, we have Tangerco as the distributing licensee. Distribution licensee is for a specified area. That area has been marked very clearly. There is no overlapping of the jurisdiction there. Once an area has been marked for one particular electricity company, then only that electricity company will be able to supply electricity to that area. So that itself is monopolizing in nature, and that itself limits competition to a great deal. So and Act also provides for the regulation of that from the hands of the Electricity Regulatory Commission. So at the behest itself, we'll have the most of the aspects of the regulation with respect to competition being taken off, because Electricity Act itself is sort of a complete code in itself, where it provides for how the sector has to be regulated. So distribution licensee will have an area of supply. Area of supply has been specifically defined in the Electricity Act. Distribution licensee is also defined in Electricity Act. Section 2, subclause 17 says so. And it is, distribution licensee is defined as a licensee authorized to operate and maintain a distribution system for supplying electricity to consumers in his area of supply. That is very important. And now we have the aspect as to whether a class of consumers need permission. It says that permission is required for another distributor of electricity to supply to a class of consumers. So let's say Tanjatco is supplying electricity to the state of Tamil Nadu, and if you are bringing some private company, let's say Adani or Reliance is coming and coming in the place of Tanjatco to supply electricity to all of you, then they will have to separately ask for a license, and then it will be adequately decided by the Electricity Regulatory Commission. And okay, so here the another aspect is with respect to additional surcharge. So it is assumed that once an area is marked for a particular distribution licensee, then that distribution licensee will invest in that area with respect to the lines and posts and all the infrastructure facilities for transmitting electricity to the end consumer. And there is a lot of investment to it. There is a lot of capital investment to it. And if a particular consumer wants to take electricity from a different company altogether, so that is possible under the Act. That is called open access. And I'll just briefly talk about open access at this juncture, because so that there'll be clarity. All right, so open access is a system where if a industrial consumer, mostly it is industrial consumer, because according to the regulations in most of the state, it may differ according to state, but most of the regulations say that if it is a consumer having more than loaded this thing of 1 megawatt, then they can source power from a different company. So let's say TTK Industries is taking electricity from Tanjatco. TTK Industries will also have the option of availing electricity for a cheaper price from a generator of electricity. Let's say Suzlon, being a wind power, is producing electricity at a very cheap cost, and they want to take cheap electricity from Suzlon because it's providing cheap electricity, and Tanjatco is charging much higher. So they can, through the method of open access that is provided in the Electricity Act itself, they can take electricity for cheaper price, but they will have to provide a payment of additional surcharge to the distribution licensee, namely Tanjatco at this place, because they have already invested into it, and additional surcharge is one way with which they can slightly reimburse their loss of losing out on a major consumer. So that aspect is also there. Again, regulated by the Electricity Regulatory Commission. We have section 17, where it says that no licensee can, without the approval of the commission, acquire or take over another company. So this is important also for the purpose of competition, because let's say Tanjatco is there in Tamil Nadu, and some other private company wants to take the position of Tanjatco. Tamil Nadu government tomorrow decides that they are going to privatize electricity sector as a whole. Some new company is coming, so they are acquiring Tanjatco. Let's assume such a thing is going to happen, in which case it cannot do without the permission of commission. That's what section 17 says. Distribution licensee also has a duty. So this word is very important. Distribution licensee has a duty to supply on request. So if you are a consumer of electricity at point X and you want electricity from your distribution licensee in your area, then Tanjatco will have the duty to supply to you. Section 43 very specifically says that there is a duty on the licensee to supply electricity if there is a request made for it. And if supply is not granted, he can again approach the state commission. So this is what section 43 says. All right, so I'll very briefly talk about the powers of the Electricity Regulatory Commission, because they are the ultimate regulators of electricity in that particular state. they have all the powers of a civil court for taking evidence and for going into the inquiry with respect to whether there is any breach of conditions, whether there is any violation of the law, etc. They have all the powers of the civil court. They have the power of even of contempt according to my submission. And we have the Electricity Commission can suo moto take cognizance of a particular issue. They can pass interim orders. They can do whatever they want as if they are a court. So they are a quasi-judicial authority also having administrative powers. They have the power to revoke the license for breach of conditions. They have the power to suspend the license if there is a breach of condition. Directions to the licensees can also be issued by the Regulatory Commission, saying that you can do this, you cannot do this, etc., etc. Power to introduce open access. This is what I mentioned earlier. If you want to avail open access as a consumer, you can do that, and that can be granted to you by the Electricity Regulatory Commission of your state. And then the question of whether an independent decision is possible on the part of the distribution licensee, that is not possible, because for everything you will have your business, the business of electricity licensee, the distribution licensee will be monitored by that agency, namely Electricity Regulatory Commission. And here, point number 8 is important because competition is again sought to be promoted by the Regulatory Commission. Now we'll just see how tariff is being determined in the sector, because the tariff determination is, according to me, the most important role of the Electricity Regulatory Commission. And what amount you pay for your for 1 unit of electricity. If you are a domestic consumer, what is the price you are going to pay? If you are an industrial consumer, what is the price you are going to pay? Everything will be taken care of, will be decided by the Regulatory Commission. 662(3) is, according to me, very important, where it says that appropriate commission, namely the State Electricity Commission, shall not, without determining that, shall not, while determining the tariff under this Act, show undue preference to any consumer of electricity, but may differentiate according to consumers' load factor, power factor, voltage, total consumption of electricity during any specified period or time at which supply is required, or the geographical position of an area, nature of supply, and the purpose for which the supply is required. So these are the conditions that govern the Electricity Regulatory Commission while they determine tariff. 62(3) is very important. These factors are also very important. Tariff is determined by the Commission by taking into account all these aspects, and it is also important to highlight here at this point that such aspects are completely taken into consideration when tariff is determined for one distribution licensee, and also because of that, amount for that you are paying for 1 unit is determined by the Commission. It's not an amount that is determined by the company. Tangerco is not going to decide what is. Tangerco will file a petition saying that I am expecting so and so amount for 1 unit of electricity, but what should be the rate is determined by the Electricity Regulatory Commission, and simply because the price is determined by the Regulatory Commission, there is no possibility of you having predatory pricing under the Competition Act. So that is also important at this stage. Now let us see what is the power of punishment for non-compliance of directions issued by the Commission. So this is something that I mentioned because we'll have to compare it with Competition Act to see what is their power. So here, if one direction is passed by the Commission, and if it is contravened, if it is not followed by the licensee or anybody who the direction was bound, such person shall pay by way of penalty, which shall not exceed 1 lakh rupees. So we read about news of Competition Commission imposing exorbitant penalty of 600 crores, 800 crores. Recently, Maruti Suzuki was found to be violating violating competition principles, and huge sums of amount was put as penalty. But ultimately speaking, when it comes to electricity, the penalty has been sort of determined by the Act itself, and it can't go more than what is mentioned here. And that is really something which will have to be taken into account for in terms of electricity reform, which may be undertaken by the government in due course. And now we'll come to the most important provision in Electricity Act with respect to our topic for the day, which is Section 60, market domination. Mr. Vishnu Rao had mentioned about Section 60 towards the end of his speech, where he said where the provision says that appropriate commission, namely the State Electricity Commission, may issue such directions, whatever direction as it pleases, as it considers appropriate to licensee or a generating company, if such licensee or generating company enters into any agreement or abuses its dominant position. So these words are really important, entering into an agreement and abusing its dominant position, because both these expressions are in the Competition Act also. Or enters into a combination. This is also covered in Competition Act. In fact, we have to now understand that Electricity Act came a year later to the Competition Act. Competition Act is of 2002 and Electricity Act is of 2003. So let us assume that the framers of the Act, the Parliament had the principles of Competition Act in their mind when they came up with this provision in the Electricity Act. So most important aspects of competition being abuse of dominant position, anti-competitive agreement, and combination. This has been impregnated into Section 60 of Electricity Act. And what is the option that is available to you? They have the commission can issue whatever direction it pleases to consider it appropriate to the licensee or generating company. So who is the authority to issue license and to whom it can be directed against is important. It says directions issued by Electricity Regulatory Commission to whom it is the licensee or a generating company. That is very important because Competition Act is applicable to all and it is not restricted to licensee or generating company. This is one nuanced area of distinction between both the statutes. Yes, so now we'll go to the Competition Act. So let's see what is there in the Competition Act's statement of objects. So the statement of objects of Competition Act says that that it is an act to provide, keeping in view the economic development of the country, for the establishment of a commission to prevent practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of the consumers, and to ensure freedom of trade carried on by other participants in market in India. Let's see what are the words here that are important. It says to prevent practices having adverse effect on competition, highlighting this aspect, and to promote it. So it starts with a negative connotation, that is to prevent practices that are adverse to competition, and then it says that it is also to promote it. So it has both the angles to it, to ensure that adverse effect on competition is not there, and also to ensure promotion of competition, to have a very healthy development of the sector. And we have the most important provisions here, namely Section 3, Section 4, and Section 5. Section 3 is anti-competitive agreements. Anti-competitive agreements cannot be entered into by any party to which would have a hindrance to the development of that sector. No abuse of dominant position is also should be there, and combination. Two companies should not come together in such a way that it adversely affects the competitive principle. 3, 4, 5 are important. There is a disturbance. There's a small disturbance. I can't hear.
You want to go on mute, please? Except the speaker, there's some disturbance.
All right. Okay. So yeah, I mentioned about 3, 4, and 5. I also mentioned that the principles of 3, 4, and 5 is there in the Electricity Act also. And then what is there in Section 18? Section 18 says that the Competition Act is also intended to remove is having adverse effect on competition and promote and sustain competition. This is what is mentioned in the preamble. Okay, so since anti-competitive agreements are essentially are 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 less in like we can say that it's not agitated a lot, because for you to enter into an agreement with another party in electricity sector, obviously there should be permission from the Electricity Regulatory Commission. And because of that, anti-competitive agreements are nipped in the bud in the Electricity Regulatory Commission itself, because it will come to them, ultimately speaking. So there is no requirement for CCI to intervene in an aspect of anti-competitive agreement, because all the agreements will be vetted by the Regulatory Commission. Combination is also one such aspect, because essentially speaking, that will also be taken care of at the level of Regulatory Commission itself. And issue with respect to competition, that aspect will also be taken care of by the Commission. What is remaining is abuse of dominant position. So this is the most important aspect, and most of the litigation is also in this particular aspect. And that is why I have extracted the section as a whole here, so that you will also have a understanding of how the provision goes. For our purposes, abuse of dominant position is the most important provision in Competition Act. And I would want you to kindly have a careful look on 4 subclause 1. No enterprise or group shall abuse its dominant position. It's very clear. It cannot be abused in any way. TANGEDCO has a dominant position in Tamil Nadu. It cannot be abused to such an extent that they are killing the sector. Let's say what section 2 says. Section 2 says that there shall be an abuse of dominant position. When is an abuse of dominant position happening? So that happens directly or indirectly when there is a condition in purchase or sale of goods or service, and when there is a price in purchase or sale of goods or service. So here the aspect of predatory pricing comes in, and predatory pricing does not arise in electricity sector because it is taken care of by the Commission itself. So that aspect is taken off. So 4.2 subclause A is taken care of. We do not have to concern ourselves with too much of it, because Electricity Commission takes care of it. What is remaining? Let's see B. B says it limits or restricts. An abuse of dominant position will be one where limiting or restricting production or goods of provisions of or provision of services of market, or technical or scientific development relating to goods or services to the prejudice of consumers. This may be relevant in our case, because for competition, this may perhaps happen in electricity sector, we do not know. C is also there. C says indulges in practices resulting in denial of market access. So there is a case law on this, which I'll refer to later. So there is a denial of market access for one particular company because of an anti-competitive practice of one company, let's say TANGEDCO. So that can happen, and makes conclusion or contract subject to acceptance by other parties of supplementary obligations. So this also to a certain extent will not be there, because Commission will have to go through all the contracts. But let's see what E says. E says uses its dominant position in one relevant market to enter into or protect other relevant market. So this is sometimes important for electricity regulatory for our purposes with respect to competition. Okay, so I demonstrated the abuse of dominant position principle, and after that we have these are the only 2 provisions which is left in Competition Act that I'll refer to, and then I'll go to the case law and I'll stop there. So here the section 21 says very clearly. So see, there are other statutory authorities that are regulatory in nature. In electricity sector, there is commissions are there, and above that appeal provision is there, and APTEL is there. So while looking into the into one particular case, and if they are finding that there is a violation of something which is essentially competition in nature, that authority can refer it to the commission. Commission here meaning competition commission. So electricity commission can refer to can refer some matters to competition commission, saying that there is essentially competition principle involved which is violated. 21A says commission is referring it to other people. So some matter is brought before the commission being the first instance court. They will look into this aspect and they are finding that this is essentially, which is technical in nature. We can't go into this because we don't have expertise. We are referring it to the appropriate commission. So they can say that and they can refer it to other statutory authority. So for our purposes, we can say that competition commission is referring it to the electricity regulatory commission. So both these aspects are covered here. CCI can refer it to other statutory authority. Other statutory authorities can also refer it to CCI. Okay, so I mentioned that, and then so the intention here is to demarcate the jurisdiction of CCI and other various sector regulators. And CCI is expected to deal with overall competition issues and any matter needing competition analysis, irrespective of the sector involved, and refer the technical issues involved, if any, to the respective sector regulators under Section 21A. Similarly, sector regulators are expected to refer competition issues before them to CCI under Section 21. I don't have too many slides left. I'll just conclude here because I think I've overstepped my time. It's already 10:50. Neeraj Malhotra is very important case. Neeraj Malhotra is also, it's a order by CCI. So Neeraj Malhotra was the first time when CCI actually looked into the whole issue with respect to its intersection with the Electricity Act. And they said that, see, essentially speaking, what we are dealing with is only competition principles. And if there is any very technical issue that is concerning electricity, then we don't have know-how, knowledge to look into it. Such technical aspects can be looked into by the concerned sector regulator itself. So Neeraj Malhotra is one case where CCI sort of restrained itself in saying that we are not overstepping ourselves and we are going to stop it here. And we'll see if there is a prima facie competition issue. And if it is not there, and if it is the issue and question is essentially technical in nature, let's say tariff, then that will be determined by the Electricity Regulatory Commission under Section 60. This is what Neeraj Malhotra says. Neeraj Malhotra case is very important because CCI is sort of limiting itself. And that position or stand of CCI has been continued in other matters also. CCI has not in any case said that, okay, we are assuming powers of Electricity Regulatory Commission. So such disputes per se has not occurred where CCI is saying that, okay, we have that power also. And in Neeraj Malhotra itself, this test is taken, which is necessary and sufficient test. What is the aspect, which is like in the tax law, the aspect theory, what aspect is covered? So perhaps, under interpretation of statutory, what is the pith and substance? So that aspect is also very important here. Only the principles, I'm not using the term, adopting the term per se, but where the provisions given in the respective statutes by themselves are necessary and sufficient to deal with any matter involving competition issues, such as anti-competitive conduct, abuse of dominant position, or regulation of combinations, that particular regulator, namely the Electricity Commission, should deal with that matter, even if it involves general underlying principle of competition. So let's say in one case, the area has been clearly covered under the Act for it to be determined by the Electricity Commission. And it is necessary and sufficient according to that case that the powers are with the Electricity Regulatory Commission, then Electricity Regulatory Commission will have the power to go into it. But if both conditions are not met, that if it is not necessary and also sufficient to deal with such aspects which are already covered in Electricity Act, then it is only then that CCI will have a say. It's only then CCI will come and step in. So that is very important. If both the conditions are not met, it is an indication that other regulator, that is CCI, has to be consulted in this case. And first regulator cannot decide the matter on its own because it is not essentially within the domain of the Electricity Commission. So it says that CCI may not go into the technicalities of electricity sector, for instance, determining tariff and technical standards of delivery, but primary issues relating to the sale of electricity and other competitive dynamics can be taken care of by CCI. So technical aspects, CCI is taking a hands-off approach. As per Section 4 of the Competition Act, first requirement is to delineate the relevant market. So we saw in Section 4 and the Competition Act, the question is also as to whether there is an abuse of dominant position in the relevant market. What is the market? So first requirement is to see whether the market has been identified. Then what is the next step? Next step is to assess the dominance of that particular company in that market. So Tamil Nadu is one relevant market, and we are looking into the abuse of dominant position of TANGEDCO. Where is there a abuse of dominant position of TANGEDCO? That is the next step. So first the market is identified. Now it is looked whether there is a dominance of that company in there. And once that also has been established, final step is to analyze the allegations pertaining to the abuse of dominance in that area. So this is how the CCI looks into a particular issue with respect to electricity. Okay, so now we are for a moment pausing here and going back to Electricity Act, because Electricity Act also has these very interesting provisions. I do not know how many people have come across it, but Section 174 says that save as otherwise provided in Section 173, provisions of this act shall have effect notwithstanding anything inconsistent therewith or contained therein in any other law. So here there is a saving provision saying that Electricity Act will have an overriding effect. Overriding effect with respect to what? It will have overriding effect with respect to competition. It will have overriding effect with respect to Railways Act, whatever act you say, they will have an overriding effect. And then provisions of this act to be in addition and not in derogation of other laws. So this is where it is important, and where CCI also has a sort of a role. So if it is a general principle nature, CCI can intervene, and if it is of a technical nature, the Electricity Act will prevail. Okay, so now we are stepping into the final aspects. So this is the most important judgment which is coming from Compat. Compat is now not there. That has been taken away, and the power is now vested with the National Company Law Appellate Tribunal. Compat held that Electricity Act actually has an overriding effect over the Competition Act. So here the issue was with respect to fuel and power purchase cost surcharge. So when tariff is determined, there is a lot of components that goes into determining tariff, and there is an additional aspect as surcharge. So these things are covered by the commission itself, and commission goes into all these aspects, and then they come up with a final tariff order. So once these are finalized by the commission, then CCI and then later Compat also said that, see, ultimately speaking, this is tariff matter. We are not going to deal with it. And commission actually has the power. Anand Prakash Agarwal upheld the order of CCI, said that technical issues, we are not going to interfere. Then there is this provision also where this is an extract from that judgment, where it says that we are of the view that an implied immunity from the competition law in matters of electricity tariff approved by appropriate commission in terms of Electricity Act 2003, and therefore appellant cannot seek any relief under Competition Act. So this is what CCI says. This is a later judgment. This is one judgment which was recently passed, where the whole issue has been analyzed. So this is by CCI. CCI went into its earlier order in Anand Agarwal and Compat's order. Here the question was with respect to denial of open access. So HPCL, Hindustan Petroleum, and Mittal Pipeline. This was one joint venture which was operating in Gujarat, and they had sought for open access. I had mentioned about open access earlier. They had sought for open access, and open access had to be approved by the state load dispatch center, being the concerned department with respect to transmission. But what happened was that it was denied. Open access was denied to HPCL Mittal, and and HPCL Mittal went to CCI saying that these people are abusing their dominant position, and because of that, we need reliefs under Competition Act. So they refer to, so these provisions are important. They refer to Section 4, subclause 2, subclause A, 1, as to say that the act of transmission amounts to imposition of unfair and arbitrary condition in the provision of services. They also said that load dispatch center has limited and restricted production of electricity and restricted the production of electricity, and therefore there is a violation of contravention of 4.2b subclause 1. And then 4.2c says that there is a denial of market access. I had mentioned to this when I was talking about abuse of dominance. There is a denial of market access also here. So they listed out certain certain violations of Competition Act and said that, see, all these provisions are violated because of their actions, and because of that we claim reliefs. But let's see what what the commission held. So it was argued that Section 60 Electricity Act is applicable only for licensees. This is what I mentioned in the beginning. So Section 60 is applicable only vis-a-vis the licensees and generating companies, and not for other people. So here, HPCL Mittal was not a licensee. HPCL Mittal was also not a generating company. So they said that, see, Section 60 is not applicable to us because these two aspects are not fulfilled. And because of that, we do not come within the jurisdiction of the State Regulatory Commission. And they said CCI has the power. This was rejected. But it was contended by the other side that open access is a different theory altogether. It is coming under 33.5. Regulation of open access would also be dealt with by the commission. So CCI does not have any power. So again, as I mentioned, it was rejected. This judgment was referred to Ashoka Marketing, Supreme Court judgment, to see if there is how these aspects will have to be reconciled in the sense that both the statutes, both are special statutes. They will have to be reconciled in a particular way, and both being special statutes, we'll have to see what is the purpose of both the statutes. And ultimately, it was held that purposive interpretation will have to be, harmonious interpretation will have to be taken into account, and that will have to be applied. And they upheld CCI said that they have the powers with respect to ensuring ensuring that there is no abuse of dominant position. They found that there is abuse of dominant position on the part of Gujarat. So they found abuse of dominant position. Ultimately, an investigation was ordered. And the most important aspect is that the question with respect to the jurisdiction was answered and said that CCI has powers if it is not something which is not technical. That again was the principle which was there in Neeraj Malhotra. That again was the principle which was there in Anand Agarwal. Upheld in these, not upheld, it was applied again by CCI. And Supreme Court judgment of Ashoka Marketing was used to say that harmonious interpretation will have to be adopted. So, okay, so CCI versus Bharti is one judgment. This is not electricity. This is with respect to TRI Act. And Supreme Court said that with respect to jurisdiction, CCI TRI will look into it. And once TRI finds that there is a competition issue, then TRI can refer the matter to competition. This is what Supreme Court said. But ultimately, it is important to say that TRI will firstly look into it, and after that comes CCI. So they did not completely eschew the power of CCI, but they said that firstly TRI and then CCI. So I'll just, okay, so I'm done with my presentation. But Mr. Vishnu Rao had also mentioned about how we need to ensure that there is a greater deal of competition in the sector to have some benefits trickle down to the consumers. And that is very important because ultimately speaking, there is only one company supplying electricity to you in Tamil Nadu and for me in Delhi, in my area. So what is important is that there is a greater deal of competition in the sector. And for that, Electricity Act is going to be amended. Electricity Act amendment bill has been drafted, and it was supposed to come this monsoon session. It was not taken up. Electricity amendment bill has a provision where it says that the licensee can further sublicense. So Tangentco can further sublicense it to some other companies of its choice for its for certain areas of supply, and ensure that there is a healthy competition within the sublicense within the licensee area. So that is one reform that is proposed to be coming. I do not know how far that will be practical in the present sense, because there is a lot of uproar and protest against it. And there was also a mention about forum of regulators. That's a great suggestion, because forum of regulators will have to be formed to ensure there is no overlap of jurisdictions and such, and there is a unity of minds. It is very amusing for me to note that electricity commissions, mostly being in the state, state subject, electricity commissions are bodies appointed by the state governments, right? So state government having control over that particular area in terms of electricity sector, and then CCI is completely appointed by the central government. So even till now, there has not been big disputes saying that we are going to assume power, and then the center through CCI will say that we are going to assume power. So such disputes till yet has not cropped up for some reason. I'm really amused about it, because everywhere else such disputes are slowly coming up. For example, in law and order, West Bengal is saying that we have to appoint the DGP, and UPSC being the national body will say that we'll give you a list, you have to pick from here. So such issues with this mostly federal nature is coming up. But vis-a-vis electricity sector and competition, such aspects have not come. But very interestingly, Electricity Amendment Act is proposing a new scheme of affairs where there is a new committee which will be appointed, which will consist mostly of central government appointees, who will now later decide who will be the Electricity Commission members. So that power of state government to appoint who are the members of State Regulatory Commission is slowly taken away. And everything will now be vested with the government itself, with the central government itself, and from I don't think much of a dispute will arise from now, because ultimately it will be the same voice, which is of the central government here. And let us hope and assume that some reform actually trickles down in the sector, which is for the benefit of consumers. Thank you so much. I'll just stop the screen share.
Thank you so much, Mukund. We will next have Mr. Ramani take over. So Mr. Ramani is going to be giving us an insider perspective and industry perspective on how exactly the industry is working, what are the challenges that we are facing from an insider perspective. So quickly over to Mr. Ramani.
Yeah, thank you, everybody. Good, nice to hear the very detailed insight through Mr. Mukund also. It's an eye-opener for me. Maybe I'm talking in between the two legal people. Hope that I'm able to come to some extent of understanding the legality at this level. I'll be more talking practicality, especially we approach the legal as a postmortem or when we land in a problem. Whereas to all the viewers, I would like to give a small rundown of how the industry has come down in Tamil Nadu in perspective, as well as general in all over India. See, maybe to start with almost 35 years experience, we realized we started with an 80 kilowatt turbine. Now we have moved out to 3000 kilowatt, almost 25 times. That's a scale of turbine capacity has gone 25 times. And you will also realize in Tamil Nadu, the installed capacity is around 32,000, and the renewable wind and solar put together almost coming to 50% of it. Thereby, there has been a lot of positive growth. And of course, challenges do come, and the potential is there. So we do overcome the challenge with proactive activities. And even technically, we'll find that lots of, even though power is generated during the wind season, we came across problems of not being evacuated with proactive cooperation, coordination between the developers and the utilities. There have been lots of substations come all over Tamil Nadu and various states also. Thereby, the limitations are converted to opportunity. And even the central government, we should appreciate they have come with a green corridor to evacuate the power from southmost of India to the northmost. So earlier there were 3 or 4 zones, what they call it, load dispatch centers. Now it has become a uniform. So what power generated during the wind season in Tamil Nadu or Kerala can be transmitted across India so that the power is not wasted. So there have been lots of positiveness which is happening around. And what we have achieved around 15,000 megawatt of solar and wind together in Tamil Nadu, we do foresee almost another 4 to 5 times is possible, even today with the present technology. So there's a huge potential available. And as Mr. Mukund was talking about, we do come across some technical and more non-technical, I will not call it legal, more non-technical problems we do come across. When Vishnu talked about consumer interest to be taken care, the industry is facing a very big challenge. The consumers are taken care, but the utilities are given a go back. In a sense, see, as a consumer, everybody would like to pay less or would like to get a free power. But even the utility has to run. You have to run positive profitability. So there has to be every year, there is something called annual revenue requirements to be given by the utilities to the Electricity Commission. In the absence of such report going, the consumer power rates are not revised. I'm using the word revised. I'm assuming it is not going upward. When we are trying to retain the power in the same slab for such a long time, maybe 5 years, 6 years, with the cost of living going up, inflation coming up, naturally it has to have an impact on the utility. They do make a lot of loss. As a consumer, all of us are happy and paying very cheap price, but directly or indirectly, everyone is impacted. See, what happens is, because the utilities are not submitting their requirement, annual revenue requirements to the Electricity Commission, there is no provision for Electricity Commission to interfere, to revise the rate. Thereby, the loss of all the utilities continue to go more and more. Even though in between, central government has come with the Uday scheme to sort of bail them out, still, in the absence of ARR being given regularly, they have a problem. So, how to ensure, maybe Mukund can highlight how to ensure, there are provisions available, how to ensure ARRs are submitted every year in time. It becomes a socio-political will. In the absence of a political will, it becomes impossible. Even a government like Andhra Pradesh, where they have done 2,000, 3,000 megawatt of renewable energy, with proper state government backed power purchase agreements, they are not honored. Now, people can go up to Supreme Court, etc., etc. The international investors have come, especially they are also facing a very bleak future about their investment. Thereby, practically, even though the frameworks are there, the ARR to be submitted, not being submitted, what do we do? Even though PPAs are there in place, it is not being honored, what do we do? So there are lots of problems we have. And another one, the acts are done with a very positive frame of mind. For example, a power generated in Karnataka, say renewable energy, they found a consumer in Maharashtra, they have a proper power purchase agreement, interstate agreement done with a proper commercial charges being paid, etc. Maybe Mukund can confirm, maybe a section 11 or something, they apply. Suddenly, abruptly, they cancel the PPA. Think about the investor who has already invested so much of money and putting the renewable energy project. The act provides state government can apply. It's like emergency. From an investor angle, we feel somewhere because we are more interested in safeguarding our interest in return on investment. Sometimes the neutrality of the law also act against the practical implication and implementation. As Vishnu was talking about, yes, especially lots of opportunity for a wind and solar available. Before that, I will talk about maybe regarding maybe I'm talking about a Tamil Nadu. See, when, for example, in India, when Tesla, MNC is coming, every company is falling over each other to give a better incentive for them to invest in India. Or recently, when Kitex industry moved from Kerala to Andhra or something, or a Telangana, they came all the offers. So in order to move the investment, one should not look the precedents. Whereas, as Mukund did talk about, somewhere down the line, the utilities play a part of, they are also a supplier, they are also a generator, and they are forced to allow the others to come in. There will be a slight apprehension about they being very neutral. Every time we can't go back to ERC and everything. And as a regulator commission, they have their own system, procedures, and time frame. So we do foresee a lot of disconnect, I will say. Even, for example, banking has been a facility which helped renewable energy to progress very fast in Tamil Nadu. Now, because in Tamil Nadu, utility is undergoing a lot of losses, they start looking at how to reduce the loss. So they are, as a chairman of TANGETCO or a TNEP, the gentleman, the IAS officer, may apply the yardstick of his balance sheet. He is right in upholding his balance sheet. He would like to reduce the losses. But because he is trying to reduce the losses of the TNEB, that could be some policies which is not investor friendly. So there has to be a political will above the electricity board, which can't be only by a electricity regulatory commission. It has to be for the government, which will look at the option of balancing between the investment obtainable versus loss they may theoretically undergo. Even one of the classic case, Aptel has asked TNRC to do an analysis or do a reanalysis of the losses, deemed losses due to banking. See, they only guide the TNRC to act. If they are not acting, what happens? The very purpose of the fight up to Apple has gone waste. So we do foresee a practicality problem of perceived losses by the TANGETCO. So we do have the banking lost. Because of that, the investors are lost. And there is no extra incentive available for the people to invest in Tamil Nadu more. And it is also a fact, earlier, individual investors were investing, and that has helped very many industries like textiles, etc., to have an edge over other people. Even internationally, they were very competitive. From an individual investors, then independent power producers came. So a lot of growth were visualized. There were lots of spurt in growth has happened. But in the process of competitive growth, in the bidding, all the people, all the stakeholders experience what should not happen. But in this process, the impact on the manufacturers, on the developer, on the bankers, everything was very huge. From the movement of independent power producers, it has gone to the next level. Independent power producers mainly selling the power only to the state electricity board. Now, Pan India, Solar Electric Corporation of India, especially SECI, has come with almost 12, 13 tenders, almost coming to 15,000, 20,000 megawatt. The price has varied from 2.4 to 3 rupees per unit. But having bid out of the 15,000, 18,000 unit megawatt of tender, hardly a 5,000, 6,000 has come. Balance could not be implemented. Again, when you ask for a utility, they will always quote the earlier lowest price and say whether you can fill it or not. They are unable to look at another aspect, why such projects are not coming. Even in Tamil Nadu, we came across tenders floated by TNEB to sell powers. That non-payment by the electricity board for the power generated, even nowadays it is up to 18 to 24 months of delay. Look at the person who has taken a loan from a financial institution is unable to pay. And there is a provision in PPA, they will give a bank guarantee, which is not being implemented. So again, what happens is there are some time frame available, there are framework available for to protect the interest of the investors. We realize it's again not getting those clauses of PPA implemented in spirit. And another classic example, as Vishnu was talking about, there's a huge potential of a rooftop on a solar with a net metering not being understood properly by various people. As an investor, I would like to export the unused power. And for example, if I generate 10 units per day, I use only 3. The balance 7 should be exported. When I'm exporting the 7, what price I get for the 7 is most critical. When will I get the power? When will I get the payment for the 7 is most critical. That's what he was talking about the net metering. We realize we have a lots of problems. And like the central government has come with lots of new incentives for production-based incentive for semiconductors. I'm sure such facility will help them, or the batteries also. The battery will become an in thing for tomorrow's renewable energy. From a solar, from the wind, the combination of solar and wind, there's another step called solar, wind, hybrid along with the battery. So that the power can be stored and it can be exported or sold whenever it is possible, required. So it will become like the round the clock concept, it is possible. So we do hope the incentive required for batteries will make it very competitive. Even the electric vehicle, I'm sure that the electric vehicle, various state governments is a subsidy. Such things should apply even for a battery-based renewables. That will help us better. And as Mukund was talking about, yes, lots of positiveness. We feel it is possible. Even the electricity commission's members, the composition of the committee itself, one can question it. It's easy whether they should be from earlier utilities or not. The combination of it's assumed that basically it's perceived the combination will be from the various walk of life from the people, rather than mainly from a one utility or something like that. So that filling up of vacancies and constitution of the members' background can also help. Maybe the suggestion as it was drafted earlier, maybe a state government, central government should also be part of selection committee. Thereby, the commission is more perceived neutral also apart from being neutral. Yeah, this is my overall perception about electricity, renewable industries potential available, as well as various pitfalls we do come across as a practicality. Even though legally we appreciate there are clauses to protect, what happens is we are forced to fight it to win the battle. But as an investor, we find that time spent on legal is not so much productive. Had it been proactively solved, will help us. Thank you.
Thank you so much, sir. That was a very, very interesting perspective that we just got. And I think there are a lot of questions that are being raised from the first as well as the presentation we have heard from Mr. Ramani now. And hopefully this is a pretty interactive session because we do have some time allotted for questions and we're expecting a lot from the audience also. So over to our final speaker for the day, Mr. Prashanth. He, in fact, is going to be addressing what exactly are the challenges that are faced in the existing regulations. So we have been given a great
Bhargavi, can we have the Mr. Prashanth also speaking? Then we'll take the questions at the last. Let us not.
So Vishnu, that was what I was saying. I said we have time allotted for questions.
Oh, sorry. I missed. Thanks.
No issues. Yeah. So like I was saying, Mr. Prashanth is going to be taking us through the challenges in the existing regulations because Mukund just touched upon the electricity bill that is yet to come into force. And we now have an understanding of what are the relevant provisions in the existing Electricity Act, what are the relevant provisions in the existing Competition Act. Can there be a marriage of the two? Should there be a marriage of the two? If it is so, how is it possible? Whether it is possible? These are all questions that all of us have. So over to Prashanth for the same. Thank you so much.
Thank you, Bhargavi. Just give me a minute, please. Yeah, sorry. Yeah. Can you hear me?
Yes, Prashanth.
Yeah, thank you. Good morning. Thank you to everybody at CAG, Mr. Vishnu, Bhargavi, Mr. Kiran. Thank you for having me over. Thank you, Mukund. Your insights were fantastic. I think set the ground for, whatever I could have mentioned. I think it was a great initiative. Thank you, Mr. Ramani. I think your industry perspectives also were very useful in understanding the industry struggles. So I think the challenge I have is to kind of cover what both Mr. Mukund and Mr. Ramani have done in different ways and try and kind of find a way between the two. So what I have just some talking points which I'm just going to refer to is the way I see it is that the where we are just to take a step back in terms of the sector itself is this sector is a little unique because that there is some history and tradition to this sector and the players in this sector are slightly different because it's a very heavily regulated sector. Now there are three types of players in this sector. There is, and I know some of this has been repeated, earlier, but please bear with me. So there are either, generators who will generate the power. Then there are transmitters, who will take the power from point A to point B, from the generators. And then there are distributors who will either distribute it to our homes or, to various, industries or industrial layouts and things like that. So historically, what has happened is that in India, except for two or three places, namely Ahmedabad, Mumbai, and Delhi, historically 95% or 98% of these functions have been government owned and controlled. As has been pointed out, various examples, Tangentco is an example, like that every state has a monopoly, distributor and a monopoly transmitter. That is one. And two is that the function of transmission and distribution is done together by the same company. What we call bundling of function. So it's a bundled product or a service which is offered. And many times the charges which are charged are a little opaque because when you pay for electricity, if you see your electricity bill which comes to your house, there is a cost of supply, plus there is a cost of bringing that power to your house. Now that includes a bundled cost of both transmitting it, which is like a highway, like a courier service bringing it on a highway from point A to point B, plus the actual fact that it comes to your house. which is the distribution aspect. So there is a retail aspect to it, there is a transmission aspect to it, and there is a generation aspect to it. Now, what also I mean, understand is that the way the Electricity Act has traditionally been done and was geared to was India for the first time privatized electricity, really in 2003. But what the idea was that at that time to privatize mainly generation and not so much distribution and transmission. So generation largely has a number of private players, and distribution and transmission is largely state-owned. And why am I mentioning it? This is because when we are looking at aspects of competition, unless first of all, there has to be players and competition in order to understand whether they are, in a dominant position, whether they're abusing the market. Now, so one analysis in terms of the Competition Act is that if the act itself, certain functions under the Electricity Act was not having players, was having only dominant players, and if generation was the only activity which allowed multiple players, then where was the aspect of competition under the act, which came up? Right, that is one question for us to examine. Yes, now generating tariffs, to give you an idea, as Mr. Ramani mentioned, is that in 2008-2009 they started off very high, like all sectors, like every other regulated sector, the tariffs started high, and as you introduced more players in the sector, they brought about ways to make it more efficiency, use technologies to make it more efficiency. So to give you an idea, the generators who were charging 8 or 9 rupees per unit in say 2007 or 8, today the cost of power is say 2 or 3 rupees, right? It has come down. Now it is not unique to electricity. If you take other sectors, you take the cost of our mobile phones were 16 and 17 rupees in the 90s and 2000. And today you have, because of competition, it is, 50 paisa or 1 rupee. So what competition has done in its own way is that where the sector encouraged multiple players, the market was instrumental in ensuring that the tariffs remained competitive and consumer interest was protected. So one of the first aspects, to examine was that did the Electricity Act meets its objective? Did the Competition Act meet its objective? Now, I would say yes, in the context of generation, they did to a large extent, because if you see historically, if somebody asked the question, today are generating tariffs competitive? The answer would be yes, because I will say that in 2007-8, what was 10 rupees is today 2 rupees. You're only paying 2 rupees. Now, if you see the reality, has our power cost gone down? The answer is no. Because if the power which you and I pay every year only keeps going up, right? It doesn't go down. Every year there is there is enough work for CAG to take up the interest of consumers, right? So the answer to that, and I feel, is that the act and the legislation, so if you look at the other two aspects which were involved, which was transmission and distribution, the act and the legislation were framed in the era where transmission and distribution were always government owned and controlled and were always a monopoly. So there was, even today, if you see, there is no, yes, whilst on one hand it is run by state owned entities, there is no incentive for state owned entities to offer competitive tariffs, because we don't know what a competing tariff is. So here I just want to make a distinction between competition and being competitive. So in generation there is competition, but in transmission and distribution, where there is monopoly players, it is anyway a monopoly today. Where is the issue of being competitive? To give you an example, one of the state distribution companies earlier this year, earlier was pointed out, the system, the way it works is every year the state distribution company in order to charge a tariff, has to go and get it approved by the local commission. That is prescribed by the statute, and that is the process which is followed. Now the process is technically supposedly a very transparent process. They say this is how we calculate the tariff, we put out the tariff, it is public consultation, is invited, public participates, whoever is affected, they will go and make an application. All this tamasha happens, and the end of it, the commission announces a tariff. Right now, to give you an idea, this year one state commission wanted initially a tariff of ₹5.85. They went through this process for a while, and then finally the commission said, no, 5.85 is very costly, and we will give you the tariff maximum you can charge is ₹5.30. So the reality is, it was seen as a big victory for the consumer. It was seen that, okay, we saved 55 paisa on the tariff. It was seen, and the commission said, look, tariff has to be competitive, tariff has to be in consumer interest, all these things. But the question is, there was nobody else, there is nobody else in the market who does that act. Today the statute doesn't allow anybody else to do that function. So where is the guarantee that could not have been 2 rupees or 3 rupees? Because there is no comparison today. So the challenge we are facing today is that in certain sectors, particularly transmission and distribution, in the absence of competition, there is no incentive for the tariff to be competitive, and which is what the current amendment or the electricity amendment bill is proposing. But also, the aspect which we should remember is that it is going to take time for competition to come into this sector and for tariffs to be competitive. You take any other sector, it takes time. You take telecom, you take airports, you take ports. There is a period of time before which it takes 8-10 years for the sector to become competitive. So the reality is that when we are looking at competition aspects, I feel that today the tariff, the statute as far as generation and transmission is concerned, is today not geared for competition in the first place. Right, there are a number of, and we'll just go through a few examples. I will just point out, because today, unless we change the statute itself, unless we make it pro competition, there is no reason today for the current monopoly player, it is a state-owned player, to even offer competitive tariffs, and that is the reality, right? So and these are some of the provisions which which Mukund already pointed out. I'm going to go over some of these provisions, but I will tell you the difficulties which are faced, so please bear with me. So for example, one, he pointed out section 17 of the Electricity Act, which briefly says that ERC permission is required for either the sale of a utility, for leasing utility, or assignments are restricted. That means assignment of the company, assignment of rights are restricted. Now the reality in this sector is that if it is government owned and controlled, especially transmission and distribution, there is no question of anybody else entering into this sector. So it was again geared for a situation where it was a government owned monopoly. So it was understandable, at that point of time. Now today, if you're going to encourage private sector to come into distribution, private sector to come into transmission, one of the big concerns of private sector would be that and typically private sector are going to grow in two ways. See, one is they are going to go around setting up infrastructure in various ways and starting from the ground. Second is they are going to take over companies who are already in that business, and pay a cost for those companies, acquire the shares of that company, and because there is a ready-made infrastructure. So if I want to what we call organic and inorganic growth, if I want to grow in that sector in a way where I'm doing M&A activity and taking over these companies, then I also need the liberty to grow that way. But for example, section 17 can act as an impediment, because when I go and try and take over a company doing transmission and distribution, I need to go and get the commission's permission. Okay, now I'm just pointing out certain impediments. Now, the second one is, if you look at the structure of, there is a section, 42, 45, which deals with duties of distribution companies, where distribution companies, it says, have to maintain efficient and economical tariffs, and charges have to be determined by the commission. So the question is that, and this is a larger question which I thought, Mr. Vishnu also raised, is that what is the role of regulation in competition? All right. And that is I think a fundamental question which, I thought we should place before this forum, because if you look at, if you are going to make it competitive, then doesn't competition itself take care? Technically the economic argument is market forces will determine tariff and the cost at which a consumer will pay that tariff. Do we then need regulation? Do we then need a commission to sit on, these people's heads and say that, you can charge X, you cannot charge Y, Y is more efficient for, because whatever, X, Y, Z, put those fetters on participants. Now today, and the question is that, on one hand, we are saying you want to encourage private players to come in, you want to encourage competition, but then shouldn't we let these private players determine where the market is? And the counter to that will be no, because even what we are allowing private players to do is we are giving them a level playing platform to come and do the same kind of operations under the Electricity Act. Look at generation, we are there are so many private players, but we are still regulating the cost at which that power is going to be given to the consumer. So now the question is that if you are going to do that, then we have to also answer the question, what is the overriding role of competition, of regulation in competition? Can I say, and who will determine that? When I go to an ERC, does the ERC in say, I'll give you an example. In Tamil Nadu, when let's say I privatize distribution, and in Tamil Nadu I go to the commission, and commission says 5 rupees is fine, it's a very good tariff, no problem, you can charge 5 rupees. I go to Karnataka, and Karnataka commission says no, 5 rupees is cheating the consumer, the maximum you can charge is 3 rupees. Right? So should the question then, for a larger question, is should regulators be interfering in competition or in fixing because there is already competition, mind you. So I'm trying to make a distinction between competition and competitive tariffs. And the act today, or the statute today, I feel is not geared for both, because on one hand they are using the word competition and competitive tariffs sort of in different circumstances, but primarily if they are going to encourage competition, then I feel that a number of sort of amendments might be required in the statute itself to bring in that. The third one was that the whole concept of open access, which was discovered, which was mentioned earlier. See, the principle of open access was that I can, if I'm a generating company, I can have private arrangements for selling and buying power. Yes, I use the same distribution and transmission network which was provided by the government companies only to supply the power. It was like, if I want to send a courier, I can use any courier company I want, but they will still use the same toll road and pay the toll. And that is what the transmission companies were charging, right? So again, the challenge will be that you on one hand are saying that you are encouraging open access, you are encouraging private arrangements. But as was pointed out tomorrow, that suppose I want to offer a premium service to a customer, whatever I say, gold package, where if you buy power from me, I will deliver it in 1 day, but it will be 4 times the cost of what you will pay to a normal person. It is a private arrangement. It is an arrangement which I have, and which, if you technically see, if you are going to encourage competition, I as a private player can come in and offer a tariff which I am comfortable with, and a private party signs with me. So the tariff need not be competitive, but it is, I'm part of the competition which is offering the tariff. So again, I'm making that distinction. And if I enter into an arrangement, now I am still be concerned, there is section 60, which is sitting on my head, which says that, if there is a, dominant, I mean, the words were, if there is an agreement, which is reeks of dominant abuse and, sort of seen as excessive, then the commission can come and cancel that contract. So every time I am going to be concerned that on one hand, I can come in and, participate in this sector, but I cannot have private arrangements the way I want. Right? Today, if I want to fly business class, I pay 50,000 rupees, nobody questions, because the regulator doesn't come into competition. He says you pay and you go. Unless when does the regulator come in? The regulator says, no, if economy class fare from Chennai to Delhi reaches 80,000, then the regulator steps in. But if the business class fare reaches 4 lakhs between Chennai and Delhi, the regulator doesn't step in. So there is a choice between being made also by the regulator when he wants to step in, when he doesn't want to step in, and it is encouraging competition. And then we don't need to meet or reach that same point as far as the electricity sector is concerned, because we are still many years away from even reaching that point, because we don't even have competition, right? The next one is that, see, the aspect is also in the context of that lot of the functions today have been framed in this sector on the basis of the fact that the distribution and transmission functions are going to be provided by the same entity. And the way that tariffs were working, is that some of the money which we were paying to the companies to take power from point A to point B was actually going to the transmission part of that business and not the distribution. What we call transmission cost or wheeling cost. And today the government is saying they are going to sort of separate this function, what we technically call unbundling. They are going to separate this function. They are going to bring in more competition in the distribution sector, which means the price which you could earlier charge for taking power, through the highway, through the courier, is no longer available to you today, because that is going to a different company. So then you as a distribution company, if you are going to, only do retail business, then the statute today mandatorily says that in certain circumstances, if I want to contract with a government company who does distribution and transmission, then I pay them a common charge, which they take the benefit of and which goes to their pocket. But if I separate this function, today the statute doesn't permit that. The statute still talks of a common sort of bundled entity. So one of the aspects would be that if I'm going to encourage competition as a generator, then I also need to separate or segregate the functions of distribution and transmission and give me that choice, because we are always talking about choice, in competition, choice of the customer, choice of the generator. When I talk about that choice, then the statute should also allow me that flexibility today to pay whom I want and to essentially use the services of which entity I want. Today that is not there, because there are certain restrictions, in the case of open access and all that. Primarily this is, if you read section 51, for example, there is restrictions where I will pay a certain cost, so that will also need to change. Okay, then the next aspect was, sort of more important aspect was that there are two kinds of tariffs which are determined. One is, and under the Electricity Act, there are two ways in which tariffs are determined. One is what is called a section 62 and a 61 tariff, where the commission determines the tariff based on certain factors. And one is a section 63 tariff, which is where a bid is conducted, a competitive bid is conducted. There are certain central government guidelines. And if a bid is conducted, based on that, whatever is the lowest price which is offered, is taken. So just to step back, when is this applicable is, what are these tariffs? These are tariffs which are used by distribution companies to procure power from the generators. So that is when these sections become applicable. So section 62 says that if I'm a distribution company and I go and procure power from somebody to supply it to, say, Chennai region, the price at which I procure power, so I enter into an agreement, called the PPA, or the power purchase agreement, and that price at which I procure power, I have to go and get it approved by a tariff. Now, as was pointed out earlier, there are certain parameters when that commission takes into account. One are certain technical parameters, but more importantly, there are sort of 2-3 interesting words which are used. One says that tariff has to be determined on commercial principles under 62. There's another section which says at the same time tariff has to be economical, has to be competitive, all that stuff. So generally that the commission every year does this balancing act, and I gave you this reason of 585 and 530, which the commission recently did in one state. So this is one impediment, because every time I have to sign a contract with the distribution company, I have to go and get it approved by the commission. Now, what was the logic? The logic was that the distribution company is government owned and state owned. Therefore, in public interest, I want to ensure that they are acting in public interest. Therefore, they are mandated to go and get it approved by the commission, and the commission will determine what is public interest. So how do I influence tariff? Because it is a monopoly. So in the absence of competition in a sector where there is monopoly, the only way of influencing or ensuring competition was through a third party agency, which was a commission, which determined what the tariff was. Now, again, to my question was, is that tariff competitive? We don't know, because we don't have a parallel entity offering a competing price. So one of the first aspects of competition is if there has to be a competitor. There is no competitor here. If there is no competitor, the commission is determining on certain basis. So it went and determined. Now we don't know whether it's competitive or not. Commission says it is in consumer interest. We have followed that, right? So this is one way in which tariff is being determined. Now the second way in which tariff is being determined is the distribution companies or the state-owned companies can conduct a bidding process. They can run a bid, a tender, invite prices from various private parties or generators and say, tell me the cost at which you'll supply power to me. Naturally, the person who supplies at the least cost will win the tender, right? So in a way, yes, they're encouraging competition. And in this, what are those tariffs, which are section 63 determined tariffs, they have to follow certain government guidelines, and they determine these tariffs based on which a PPA is signed. In those cases, it says the commission does not need to approve the tariff. Whatever is being determined by the market can be, agreed to by the distribution company. This is the present arrangement. So either I go to the commission or I run a bid. Now, if I want to bring in competition into this sector, when I bring in competition now, if let us say we'll have to also determine what is the role of regulation, because then the question for us is that do we need to still have a 62 or a 63? Because if there is a private player who then he may offer whatever tariff he wants today for offering a tariff. If the commission, the question for us is, does the commission still have a role in the era of competition? Because do I still want the commission to determine tariff? Now today, when you want to use an airline, say you want to use Indigo or SpiceJet or Go Air, every time do they go to that commission or to ERA to say that I'm going to charge 6,000 rupees from Chennai to Delhi, 8,000 rupees from Chennai to Bangalore? They are not doing that. They are free to determine what they want. So if you look at other sectors, competition means also that the regulator steps out in some way or the other. Yes, there is a role for regulator to play in sometimes in technical aspects, maybe safety aspects, maybe certain other. But one of the questions again for us to answer is that what is the role of regulation in competition? Now today, in the absence of competition, the regulator has a very heavy role. Almost he's the dominant role. But when we are sort of, it's like a pendulum. When we encourage competition, shouldn't the role of regulator keep going down and down, right? Because then we want competition and market forces to determine, what should be the price point at which consumers should benefit. and it may well be the case that consumer, it may still be high. So we don't know if again competition is the answer to economics, but that is the role which sort of competition will need to play, and regulator will need to step out. And today that is where we are in terms of the act, where the act doesn't encourage regulators to step out. In fact, they have to step in at each of these circumstances. And if I am a private player, why will I want to do a bid? Suppose I want to negotiate. I'm tomorrow I negotiate that in, say, in Post Garden, which is a very posh area, I will offer gold tariff. I will offer gold supply at 3 times the cost, because I know the people can pay for it. I should be able to offer a product like any other premium product. Now, should that be allowed? Because today it is not allowed, because when I'm bringing in competition, then shouldn't the regulator be stepping out, right? So this is the next point. And if you see, now let us look at some reality, of there were 2 or 3 instances where distribution has been privatized, in 3 cities, some parts of Delhi, as in where Mukund stays, some parts of Bombay, and some parts of Ahmedabad. There is a private sector, private player in these jurisdictions who is supplying, who is distributing power, and the private sector is controlling distribution. Now, if you ask anybody, in these regions, is the tariff competitive? Has your power cost gone down? They will say no. In fact, it has gone up. The private sector will say that I came in, I set up better infrastructure, I set up call center, I set up 24/7 customer care center. My entire infrastructure cost has gone up. I am controlling losses, and therefore I should be able to charge you more and not less. So the question for us is, did competition result in economies of making the tariff more efficient? The answer is possibly no. Right, because if you take instances of any other sector, you take the airport sector, you take, so there is competition, there is market forces in play. Now, does it then mean that moment we bring in competition and we determine what is control, market control, then does it mean the reality is that it is going to be no longer economical or efficient? Because the Electricity Act, like every other legislation, exists in tandem. It uses the word economics of sale, it uses the word efficiency, it uses the word consumer interest. These are the words which are used in determining tariff at generally. But the question again to answer is, if we are going to encourage competition, then do we need to amend the Electricity Act and say no, it is as determined by market? If it is consumer interest, yes, but if it is not, that is what the consumer has to pay, because that is what competition is going to achieve, right? So the I would say these are sort of where we are in terms of broadly, and we are at the stage we are, as was discussed, there is a new amendment on the anvil where privatization is going to be the distribution is going to be privatized. The idea is they're saying they will give more consumer choice, and the question I really have is that by encouraging competition, is it pro or anti consumer? Today, where is the answer that if I privatize distribution and I bring in private investors, they will retain the same tariff which Tangent was giving me? Maybe they will make it 5 or 6 times higher. But what if there are 2 private players or 3 private players and all of them make it higher? Right? How do I control that? So the answer, the question I would say is that are we today saying that by competition, are we also saying that by encouraging competition we want them to be competitive, or it is just we stop at you encourage competition? And today I think the act is not very clear on, are we trying to be competitive or are we encouraging competition? I think that answer has to be made clear. So I think, broadly to summarize, I think sort of we are at the cusp of, I would say, something very interesting where it is very peculiar to this sector, where one aspect is competitive, or there is competition, which is the generation aspect. the transmission and distribution aspect, which is in sync with this function, is not is still government owned, and we have a many years before that sector where there is competition comes in and it becomes competitive. So we are going to have a mix of sort of the sector being not competitive and competitive. And I think the and if you see the Competition Act, as was pointed out, in many cases says that the Electricity Act will prevail in terms of determining what is competitive, in determining what is the dominant player, determining abuse. And I think those were all done in an era where it was government controlled and owned. So but today, if you are going to encourage private players, then the definition and the concepts which were enshrined in the statute will, I think, fundamentally have to change. They cannot use the same definition which was there possibly, say, from, I would say, more socialist leanings, and apply it to a market sort of force definition, because I feel they may not be in sync, and some thought will have to be given on whether these provisions of the statute will fundamentally need to change before they bring in the private players. So I think that is the biggest challenge I see in terms of encouraging competition, because and I feel that we are still some way away, because unless there is competition for a few years, how do we determine whether it is abuse, whether it is dominant position? Today there is nobody. There is only a monopoly of government agencies who are already dominant or already abusing. They say they are not, but we don't know, right? Unless there is a competitor, we don't know if they're abusing or not abusing. We don't have competition to determine. So I feel we are still some steps away from even understanding competition in this sector. First we have to introduce competition, see who becomes dominant. Now to give you an idea, in the airport sector today, Adanis have owning 6 or 10 airports. They have won through a bid and they are controlling that. Now they will say that we came in through a competitive mechanism. We bid, we won fair and square, and we are got control of 8-10 airports, and we are able to charge what we want. Now, is that dominant or not dominant? The question will come in today, after they run it for some time, and people will say that they are controlling it. But if you are not even in that stage, maybe we are 5-10 years before that, I still feel that unless we cross that stage, only then we will know what is abuse and sort of dominant position. So I would say these were sort of some concluding thoughts. Again, I will end here. Thank you so much for the opportunity.
Thank you so much, Prashanth. Those views were quite remarkable in the sense that I did have a set of questions that I wanted to target to you. But your constructive comments so far have answered most of the questions, especially when it comes to the conflict between competition and regulation in the same sector, and how is one supposed to thrive in the presence of other, and the role of consumer choices in this segment. There are also some questions from the audience, and I do have certain questions from my end. I will just fuse them together and present it to both the speakers. I believe Mr. Ramani had to leave urgently, so therefore it leaves us with Prashanth and Mr. Mukund. My first question in terms of regulation and competition. In fact, I meant to ask you, if competition has to survive, what are the avenues in which the regulation must step back and leave room for competitive elements to take pleasure? In your comments, you were quite bold to suggest that the whole tariff mechanism itself could be changed into a competitive process, where the prices can be fixed through market factors and the competitive determination of the private players. In addition to the tariff areas, are there any other aspects which the regulation must step back so that the competition players can come and occupy those fields? For example, if I can just give an example, that in the existing setup, it is divided by geographical market. Players are confined to each state, and within the state, there are subdivisions and etc. Are these some of the things that can be changed, and the regulators can stop regulating these aspects so that the competition can foster? This question is to Mr. Prashanth. In addition to tariff, what are the other areas under the Electricity Act that must necessarily be deregulated so that competition can thrive?
Yeah. So I thanks, Kiran. See, so I mean, I'll be honest that there are many areas, where some deregulation will help. But I think, for example, I pointed out, say, open access. Now, the current provision, of open access under 42, says that a bundled sort of cost has to be paid, towards transmission infrastructure when you get an open access approval to the counterparty. So again, if you are going to split and sort of unbundle this, then there could be a benefit. So to give you an idea, I could choose to go with which courier I want. Right, and in simple words, I could choose either the highway and pay extra toll, or I could choose a side road and pay less some toll. So if I'm just saying that, if I have a open access arrangement with a side highway fellow where he's going to charge less but it takes 3 days more, for maybe certain customers I may prefer that, or they may prefer that. So I'm just giving an example, like, open access could be an area. There is this whole concept of see, I'm currently dependent on the technical side and on the infrastructure side. Particularly, this sector is very sort of technical infrastructure oriented, because it is a monopoly which is again controlled. The entire sort of grid network is controlled by the government players. So I'm highly dependent on them to move power from point A to point B. And today they are selling it as a common product along with the distribution companies. But what if I can, unbundle that? And I'm just saying that if I can choose the way power will be transmitted, I given some flexibility, because today I don't have that flexibility because of various technical reasons. But if I can bring in flexibility in the way I can supply and things like that, then I feel that there is sort of work to be done. So I would say, broadly speaking, other than the tariff aspects, there are various technical aspects to encourage supply in a more competitive manner. They could be. This sector has a lot of historical baggage which needs to be, I would say, sort of undone with, because it is where private sector will step in for the first time. Right, and that private sector will take 10-15 years to learn and really understand, and overnight they cannot go set up a highway. They will have to set up slowly, one road, second road, third road. It will become a highway someday, and then there will be choice available to the consumer. So we are still many years away from that. So I would say all that work is still there.
Speaking of choices, this in fact leads me to the second question. These concepts such as open access, and even later I read about energy exchanges where companies can directly purchase. These seems to be very innovative options for high tension consumers, for massive big corporations. What could be the options for a domestic consumer or a small time consumer, where it may not be feasible for being a domestic user for me to participate in the open access process, or directly procure it from the generator and pick my transmitter? Those would be concerns beyond my scope. For a domestic consumer, how can the competition help in introducing more access? Rather, what could be more access for a domestic consumer in this sector? This question, I think I'll first go to Mr. Mukund and then again come to Prashanth, because I would like both your views on this.
Thank you, Kiran. See, this sector as such is consisting of, let's not look at from the perspective of one who's selling it. Look at from the perspective of one who is consuming it. So we have different types of consumers. We need to understand who are the stakeholders here. So one will be like you and I consuming electricity at our homes. Then we'll have farmers who would be consuming electricity to use their pump sets, small consumptions like that. And then we have small time medium MSMEs and small businessmen and then it will slowly scale up to big high tension consumers, etc., etc. So that's, see, so exchanges are a plausible mechanism when it comes to high tension consumers and big industrial consumers, because it will be affordable for them to, like go to an open market, purchase some electricity on bulk, and then bring it to their respective state, etc. But for a consumer who's like you and me, a domestic consumer, I think reforms are still far away, for the reason that one, the electricity amendment bill is proposing the new system where there will be a sub licensee, where the main electricity licensee will probably sub distribute. They'll have a franchisee system where new players will be there who will be the access point to the end consumer, right? So to ensure there is a last mile connectivity, they are ensuring that there is one more entity in between the main distribution licensee and the consumer. So how that is going to actually play out is something which we'll have to, like now wait and see, because they are trying to conceptualize a system where they'll bring private players in distribution mechanism, where they'll bring private players here as the intermediary, as the franchisee mechanism. But see, from a industry perspective, and it's something very important to note, that private players have entered distribution sphere, and places where they are not making any profit, they have gone back. For example, in the state of Orissa, they were in the business and they did not make any profit, because that state was predominantly rural and agricultural, and a big play, although there are some industries, but they were not making much money in that particular state, and because of that they pulled off. So privatization was a failure in Orissa, and we are now again coming forward with the idea that, okay, we are going to have more private players. But see, look from the perspective of private players, they'll be entering a market only if they are going to make profits. For example, they are in Delhi because Delhi is a predominantly urban area where they'll be able to make profit. Let's take the example of Bombay. They have Tata Power, Adani and whatnot, because they are making profits. But for an end consumer, for a rural, okay, for in Madras also, they may probably be able to make profits. But what about consumers? And let's take the example of Villupuram or some Pollachi or all these villages. Coimbatore is still a little more industrial. So we have to take into consideration all these aspects. Are the private players going to enter these areas, these rural places where the rural consumer will have an option? Are they going to enter these places? Is something we'll have to look and see. Government is engaged on a day-to-day basis, because of the reason that this is a very populist issue, right? So the one unit, how much the electricity one person is going to pay, ultimately determines his entire expenses for a month, even for a small scale consumer, or for a farmer, for a MSME, businessman, etc. So it's a very populist issue, and government, I think, will have their hands-on approach. At least the state governments will have their hands-on approach. But again, it is up to, we'll see what will happen once the new amendment bill is tabled, and once that become operationalized, because that's something that we'll have to now wait and see. There are many practical problems, but how far the sector is going to overcome the practical problems is something we'll wait and see in the future. I'm actually looking forward to Prashanth sir's comment on this, because one of his expertise. Yeah.
Yes, Prashanth sir.
Sorry, will you just frame the question?
Yes, in fact, I will also add one more layer to the question, because Mukund also made a very interesting observation. The initial question was, as an end consumer or a low-end consumer, a domestic consumer, what could be the options that I have through competition enhancement? Because all the avenues so far explored, such as open access and exchanges, are all applicable to high-tension consumers. How viable, or what are the viable options to increase choices for a domestic consumer? This was my question. I'll add the sub-question later, sir. Please go ahead with this.
See, so today, the choice is very difficult today, because the reality is that um, the infrastructure, which supplies power to yours and my house, is all monopoly owned and controlled. And that like I said, the power which comes to our houses it comes from somewhere, wherever it is generated. So that entire because what has happened is, historically it was always felt that this function was a government function, and government controlled not only the economic function of supply, but also control the infrastructure around that supply. It is like railways, where they have, it's their railway line. Even if I want to run a private rail, I still have to go to railways and run on their line. I can't put my private line, right? So the question is that when can I have choice, and what is the type of choice I can have, right, for a customer? Now, if I can, at the most, what can I do? I can, let's say, if I'm just giving an example, say tomorrow Airtel comes into power distribution. I want to port my meter from Tangent Co to Airtel. Can Airtel take power from point A to point B? The answer is no, because even if Airtel supplies that power, still it will depend on Tangent Co for moving power from point, because Tangent Co owns all the networks and all the roads today. Airtel is going to take another 30 years to, even if it has to put a grid and a infrastructure, it will take 30 years. So today choice is going to be determined by what is the choice which a competitor is going to offer to me in this sector. And the answer would be that a lot of it will depend on, if the government says, and the government has said that, what is called the principle of common carrier, which is, if the government says that you distinguish transmission and distribution, and whoever comes, tomorrow, whoever comes should be allowed to use the highway. Your highway is meant for, it's a different company, you are not going to interfere with that function. If it is tomorrow Airtel, if it is tomorrow some other private player, if they want to use the highway to supply power to Kiran, they should be allowed to do that, as long as they pay that cost. So the first function is the today they have to unbundle all these companies. It's not easy. 20-30 distribution companies, they have to unbundle that function and segregate transmission, because then Airtel will directly contract with the transmission company. It doesn't have to contract with the distribution company, right? But unless that happens, it cannot offer me choice, because there are only two ways of doing it. Either I use existing infrastructure, contract with the distribution company and go to Kiran, or I put my own network tomorrow, spend thousands of crores and go to Kiran. Now it's unlikely the latter will happen. So I feel that we are still some years away from choice. Yes, there is choice in generation, where I can do private arrangement. If I'm and it is happening. You say you take a large IT park, SEZ park, large colonies where there are 500 apartments, where directly suppliers are approaching them saying, I will put a direct line to your house. I will put one transformer station outside your house. I will bring power. You don't have to go through, all this network. So in small ways, choice will come. But really, for sort of, I think, a mass consumer to benefit, like mobile phone, what happened where, every person had a choice, that is, I think we are still some years away.
Perfectly put, sir. I also feel that.
I'll just take one example of petrol and diesel deregulation.
Right.
It was publicized in such a manner that the price of petrol and diesel is going to come down, because now the government control is not there. It will will ensure the market forces control the prices. There will be greater consumption. Prices will come down. That was the perception. Right now, even though the international price of crude oil is so less, we are paying a bomb for petrol and diesel. And see, this is probably going to happen with the electricity sector also. So I'll take one example of telecom. So Jio was competitively priced. There was predatory pricing issue. It was taken up by Airtel for the CCI with the audience. you have some 3-month arrangement or something like an introductory pack. You can have 3 or 6 month, like offer. Jio accepted it. What they did was they extended this thing for another 3 or 4 months, and then the Airtel had to again go back to try. And now, what is the situation? Competition is practically nil in the telecom sector. We have only Vodafone is gone. I don't know how Airtel survived in that AGR case, but any case, in anyway, we only have Airtel. Jio is right now in a position to charge whatever they want, and now the prices are again going up. Jio is now pricing very aggressive. Sorry, the pricing it higher,
Absolutely.
not aggressive. Yeah, so let's see that these are the pitfalls when it comes to privatization and when it comes to like completely deregulating it. Unlike telecom, this affects life of you and I. Like you see, for a farmer, it affects his livelihood because pump set and all these things, and for us also, it affects in a whole different sort of ways. We all know that.
Absolutely.
Yeah, so such aspects, these are all broad picture things which I don't know, and this is the reason why state governments and the governments are not taking a very like hands-offish approach, because ultimately they will have to go back to the people to get them elected. So such aspects are there, which I thought I'll.
That was an excellent analogy, especially with the price of petrol and diesel. It is regulated by the government, but that does not mean that it is the most competitive offer that can be given to the people. So sometimes competition is required to show us a benchmark and understand what can be a good choicey offer as opposed to a purely regulation approach. I do have plenty of other questions, but unfortunately, we are running short of time, and I'm also being politely nudged by the organizers to wrap it up. So my sincere thanks to both the speakers and CAG. This was a very, very enlightening session for both, at least for myself and Bhargavi, where we learned an incredible amount of information in this rather exclusive sector. One of my our personal difficulty was accessing resource people in the electricity sector, because not a lot of experts are out there, and we are extremely fortunate to have 3 of them with us and share their experience and views. We are very grateful for this session. So thank you, Mr. Mukund. Thank you, Mr. Prashanth. It was lovely having you both. Thank you.
Thank you.
Thank you. Thanks a lot. It was really great to
On
present.
behalf of CAG, we'd like to thank you also for joining. It's a very new topic for us, and new faces. We see a lot of people in the electricity sector who are very technocrats, but it's a fresh perspective that you both have brought in. Thank you very much.
Thank you.
Thank you.
Thank you.
And happy to be involved in future.
Yeah, please, we'll keep in touch, of course.
Sure.
Thanks.
Thank you.
Okay.
Thank you.